President Donald Trump has signed a major executive order on the Second Amendment that could reshape gun rights across the United States. Gun owners in restrictive states such as California, New York, and Illinois may soon gain privileges they never had before. Signed on Monday, the order relies on Article 2 authority and the failure of Congress to act, introducing 5 key directives. These include national concealed carry reciprocity, removal of suppressors and short-barreled rifles from National Firearms Act registration, elimination of gun-free zones on federal property, federal preemption of magazine limits, and restructuring of the ATF. The measures take effect in 30 days and apply nationwide. Gun rights groups describe it as the most significant expansion of Second Amendment protections in 50 years, though 15 states are already filing lawsuits claiming it exceeds presidential authority and violates the 10th Amendment. The legal outcome will determine whether gun owners can exercise full Second Amendment rights or if the order is overturned. After Republicans failed to pass national reciprocity despite controlling Congress, Trump acted unilaterally. His legal team cited the Bruin decision, emphasizing historical tradition, and argued the federal government has a constitutional duty to protect enumerated rights from state infringement. The signing at the White House included leaders from the NRA, Gun Owners of America, and Second Amendment advocacy groups. Trump stated, "Law-abiding Americans are treated like criminals for exercising constitutional rights. Today, we restore the Second Amendment. The first provision is carry reciprocity, which requires all states to recognize valid permits from any other state based on the full faith and credit clause. Permit holders from constitutional carry states like Texas, Florida, and Arizona will benefit the most. Previously, New York, California, and New Jersey refused recognition. Now, a Texas license holder can legally carry in Manhattan, Los Angeles, and Chicago. Florida permits will be valid in Boston and Seattle, and Arizona permits will work in Connecticut, Maryland, and Rhode Island. States cannot impose additional requirements beyond what the issuing state requires. Exceptions remain for residents. California residents still need a California permit to carry within California. This change only affects out-of-state recognition and does not override federal restrictions on schools, courthouses, or gun-free zones. States resisting compliance include New York, California, New Jersey, Massachusetts, Maryland, Connecticut, Rhode Island, Hawaii, and Illinois, all filing lawsuits citing violations of the 10th Amendment and state sovereignty. The second directive concerns NFA deregulation for suppressors and short-barreled rifles. The order directs the ATF to remove suppressors and short-barreled rifles from NFA registration, arguing they are neither dangerous nor unusual under the Heller precedent. There is no historical tradition of regulating suppressors or barrel length. Currently, suppressors require a $200 tax and months of ATF processing. Under the order, suppressors will be treated like regular firearms purchased from licensed dealers, with only a standard Form 4473 required, and no tax or registration. Existing registered suppressors remain legal, and owners may deregister them. Short-barreled rifles under 16 inches will no longer require NFA compliance, and will be treated as regular rifles. AR pistols with braces will also be exempt from NFA rules. The order allows building ARs with brace stocks and barrels without NFA registration. About 2.5 million suppressors are currently registered, and owners can save $200, avoiding 6 to 12-month waits. Privacy is maintained with no ATF tracking, and new buyers can make same-day purchases. Short-barreled rifle deregulation benefits AR pistol owners, home defenders, and hunters seeking compact rifles. State bans remain, so California, New York, New Jersey, and Illinois still prohibit suppressors. Federal deregulation does not legalize them in those states, but 42 states that permit suppressors no longer require federal registration. The third directive removes federal gun-free zones on federal property, except courthouses, secure facilities, and areas specifically prohibited under 18 U.S.C. Section 930. Federal agencies must revise policies within 30 days to allow concealed carry by permit holders. This opens national parks, national forests, BLM lands, federal office buildings, post offices, Social Security offices, VA hospitals, federal housing, military bases, Army Corps lands, wildlife refuges, and military installations to permit holders. Civilians with valid permits may carry on military bases, though active duty military remain under separate UCMJ authority. Exceptions remain for federal courthouses, secure areas under 18 U.S.C. 930, federal prisons, and areas behind security checkpoints. General federal buildings without screening now allow concealed carry. State and local property are unaffected. States, counties, and cities may continue designating their property gun-free. The fourth directive establishes federal preemption of magazine limits. It declares state restrictions unconstitutional under Bruin, directing the Attorney General to file lawsuits challenging all bans. Federal agencies are instructed not to enforce state limits on federal property. This sets a federal floor of no restrictions. States affected include California, New York, New Jersey, Massachusetts, Maryland, Connecticut, Rhode Island with 10-round limits, Colorado with 15 rounds, Washington, Vermont, and Illinois vary. All limits are now challenged federally. Legally, standard capacity magazines, 30-round ARs, 15 to 17-round pistols, are protected by the Second Amendment. Historical precedent shows no traditional restriction on capacity. First limits appeared in the 1990s. Bruin requires invalidation, and the federal government has a duty to protect constitutional rights from state infringement. Immediate effect is limited. Limits remain enforceable by states until courts rule. Federal law enforcement, including ATF and FBI, are instructed not to assist state enforcement. The Fifth Directive restructures the ATF to focus on criminal enforcement rather than regulatory actions against lawful owners. Priority shifts to prohibited persons, traffickers, straw purchasers, and criminals using firearms. FFL inspections, paperwork violations, and unintentional regulatory errors will receive a warning and opportunity to correct. Previously, a single Form 4473 error could revoke a license. Under the order, revocation occurs only for willful violations or patterns of abuse. This reduces fear of losing licenses for mistakes. The pistol brace rule is formally rescinded, eliminating the previous registration requirement. Combined with short-barreled rifle deregulation, all AR pistols with braces are now legal without NFA registration. About 40 million braced pistols are affected. The previous zero-tolerance policy has ended. FFL violations no longer carry automatic revocation. ATF will balance compliance assistance with enforcement, prioritizing education before punitive actions. President Trump signed the Second Amendment executive order on Monday, introducing 5 major provisions that could fundamentally change the gun rights landscape. National concealed carry reciprocity requires all states to recognize valid permits from any other state. Holders from Texas, Florida, and Arizona can now carry in New York, California, and New Jersey. The order takes effect in 30 days, eliminating the patchwork of state reciprocity agreements that previously exposed gun owners to felony charges when crossing state lines. NFA deregulation removes suppressors and short-barreled rifles from registration requirements. Suppressors can be purchased like regular firearms with no tax stamp or registration. AR pistols with stocks and short barrels no longer require NFA compliance. This impacts 2.5 million existing registered items and millions of future purchases. Industry predicts tenfold growth in the suppressor market. Federal gun-free zones are eliminated, allowing concealed carry on federal property, including national parks, post offices, federal buildings, and military bases for civilians with valid permits. Exceptions remain for courthouses, secure facilities, and areas prohibited by statute. Hundreds of thousands of federal properties, previously off limits to armed citizens, are now accessible. Magazine limits are being challenged. The federal government is filing lawsuits against all state magazine capacity bans in California, New York, New Jersey, Massachusetts, Maryland, Connecticut, Colorado, Washington, Vermont, and Illinois. Limits are now under coordinated federal challenge alongside gun rights organizations. ATF enforcement priorities have shifted from regulatory actions against lawful owners to criminal prosecutions. The zero-tolerance policy has been rescinded, and the brace rule affecting 40 million AR pistols is removed. Resources are redirected toward prosecuting traffickers, prohibited persons, and straw purchasers. Legal challenges are underway. 15 blue states argue the executive order exceeds presidential authority under Article 2 and violates the 10th Amendment, which reserves police powers to states, challenging state sovereignty over public safety regulations. Cases are expected to reach federal district courts within weeks, circuit courts within 3 to 6 months, and the Supreme Court within 6 to 12 months. The outcome remains uncertain, potentially upheld as a valid exercise of federal authority to protect constitutional rights, or struck down as executive overreach. Gun owners should prepare. If you hold a concealed carry permit from any state, you may travel to all 50 states once the order takes effect in 30 days. Carry a copy of the executive order and be ready for possible confrontations in non-compliant states. Suppressor and short-barreled rifle owners should monitor ATF guidance on deregistration. FFLs should document compliance efforts to benefit from warning-based enforcement. Magazine-restricted state residents should support litigation efforts and track court decisions. Stay informed as the Second Amendment executive order is being challenged in courts. Its legal fate could represent a historic victory or be overturned, and understanding the changes is crucial for exercising full constitutional protections. Please leave your thoughts about this content in the comments below. Thanks for watching. See you in the next one.